You are listening to Based in Fact, a true crime podcast. Join host Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to Season 3 of Based in Fact, a true crime podcast. We're your hosts, Lisa O'Brien and Kyle Evans, and this is Episode 7, State of Florida versus Dalia Dippolito, Part 2. We'll conclude our look at this long-running case and talk about Dippolito's two retrials, one of which ended in a mistrial, and the other which concluded in June of 2017 with a conviction for solicitation to commit first-degree murder with a firearm. Then we'll look at her direct appeal and state post-conviction claims, and finally preview the claims that will be considered by the federal courts in her federal habeas appeal. Good afternoon, Kyle, and today is Sunday, May 12th. It is Mother's Day in the United States, so happy Mother's Day to all the mothers out there.
Yeah, good afternoon, Lisa. How are you? Yes,
Very
happy Mother's
well.
Day to all the mothers out there.
And my sister and my niece included, all the grandmothers as well.
Yes.
So, and your lovely wife.
Yes, happy Mother's Day to her and our two kids. She's glad that she likes to be just left alone on Mother's Day out of her hair, although she did assign each of us a room to scrub and clean. So I will be behind and I don't know which room I've been assigned, but I will have
Okay.
to scrub and clean a room when we're done today.
Okay, well that's fair. That's fair. All right, well let's get into part 2 of Dalia Dippolito. We are, of course, talking about the attempted murder for hire of Michael Anthony Dippolito. He was born December 18th, 1970 in Philadelphia, Pennsylvania. His father was Edward Dippolito Sr. His mother was Joan DeVico, who died on around February 19th, 2021. He has a brother, Edward Jr., and a sister, Christina. He graduated from Central Bucks High School East and went to Montgomery County Community College. He is a businessman and has been a realtor in the South Florida area. He was married first to Maria Rosario Luongo from 2007 to 2009. And then he married Dalia Adel Muhammad, 2009, and that was the beginning of his troubles. He also has a daughter with a woman in Broward County to whom he was not married. Then we have our perpetrator is Dalia Adel Muhammad Dippolito. She was born October 18th, 1982 in Queens, New York. Her parents are Adel Muhammad and Rhonda Gonzalez. She is the oldest of 3 siblings. She has a brother, Amir, and a sister, Samira. She went to a high school in Lantana, Florida. I can't remember the name of it. I had it in my notes, but I apparently must have accidentally deleted it. She was married to Michael Anthony Dippolito in February of 2009. They divorced in 2011. And the irony of that is that she wanted to kill him in 2009, but she fought the divorce until 2011. So,
Did a piece of work.
yeah, she has a son who was born in March of 2016 while she was on house arrest. She is manipulative, a liar, a thief. She's also vindictive. She was at one time an escort or a prostitute. She also tried to be a madam, and that didn't work out for her. She stole money from Mike Dippolito. She probably stole money from other men. She has forged documents to try to bolster her claims or to try to convince people that she didn't steal from them, including Mike. She's made false reports to law enforcement of drug dealing and domestic violence against Mike, and she has committed perjury when she swore under oath to tell the truth, the whole truth, and nothing but the truth in February of 2016, and then testified that the whole murder for hire thing was an actor's project cooked up by Mike to try to get acting jobs based on Muhammad being in an episode of Burn Notice, which I
mean,
think
give
if
her
you
credit for
blink,
being,
you
give
miss
her
him.
credit. Yeah, give her credit for being creative at least.
So, and her attempted victim was Michael Dippolito. Now, Michael was the victim of multiple crimes committed against him by Dippolito, including the theft and the attempted murder for hire. And there's not really a single date with that, because it was committed over, the murder for hire was committed over a period between March and then resuming in July 2009 and completed when she, quote, hired a hitman on August 3rd, 2009. But let's go through just kind of a quick recap. Of course, Mike, first to admit he's no angel. He was indicted for 7 counts of financial crimes in 2001. He entered a nolo contendere plea in 2003 to 3 counts of those crimes. He went to prison in the Florida Department of Corrections. He was released on January 24th, 2004. Mike has been clean and sober since his incarceration. And he has remained clean and sober even through all this bull crap with Dalia. So, and I think that bears emphasizing. On July 16, 2007, he married Maria, who was a longtime girlfriend. They were together, I think, about 7 years. She even stood by him when he went to prison. But then in October of 2008, he blew it all up when he hired Dalia Muhammad as an escort and then started an affair with her. On October 23rd, 2008, in less than a month, he filed for divorce from Maria. That was probably, I would say, the biggest mistake he ever made in his life.
For sure.
Because what he should have done was he should have cut Dalia loose and stayed with Maria, because she sounds like she was probably a very good woman and probably better than what he's ended up with Dalia.
Yeah, seriously.
And I think since Dalia, his fame has led to a couple of unsuccessful relationships. With
it's got to be hard at this point to find
other
any
women.
normal person.
And I think he's currently unattached. On January 28, 2009, he purchased the condo on Via de Pepe in Boynton Beach, Florida. On February 2nd, 2009, he and Dalia were married. She began almost immediately stealing money from him under the guise of saving it for him to issue a check to pay off his restitution. She offered to put her own money in to do that. On February 20th, 2009, Mike added Dalia to the title of his house.
Yeah, that was his first mistake, or his second mistake.
Second mistake. And that is probably when she started thinking about killing him. Beginning in March of 2009, she started trying to find someone to kill Mike, including trying to hire members of a Palm Beach gang. I think it was Buck Wild or something. The name of the gang was really odd. And they luckily, I think they took some money from her, but never followed through. Now, on March 3rd, 2009, Dalia created a fake wire transfer document for a bank in the Cayman Islands to bolster her claim that Mike's attorney stole his restitution money that she claimed to have sent to the attorney, when in fact, as he gave her money, she spent it. She gave money to Muhammad to buy a Range Rover, which she then promised to the hitman in Riviera Beach. And then he ultimately sold it. On April 3rd, 2009, Eric Tall, a friend of Dalia's, stole $150,000 from Mike on
Jeez.
April 1st, 2009, or after April 3rd, 2009. Mike's attorney at the time fired him because all this bullshit with the restitution money that he was supposed to be getting that wasn't a guarantee that Mike would get off probation, but it would help for a potential early termination. He fired him as a client, so Mike then had to basically start the whole process over again. Plus, he was out over $200,000. In July of 2009, Dalia and her former client, boyfriend, lover, Mike Stanley, begin trying to get Mike's probation revoked. They make false claims to police and probation, accusing Mike of domestic violence and selling drugs. They use spoof numbers to pose as an attorney for Mike. In July of 2009, or around July or June of 2009, Mike found drugs that had been planted in his car. His car had been searched, but they weren't found during that search, and he disposed of them. And then later, a short time later, police did search his vehicle and did find drugs, but they found him in an odd place under his spare tire. And Mike's reaction was so genuine that the cops believed his claim that somebody was trying to set him up, and they let him go. And when he turned around and asked Dalia that, she started driving like a maniac, and made him actually fear for his life, and my connection became unstable. Okay,
Yeah,
I'm
I was
back.
gonna tell you were out for a couple of minutes, but you're back. Yeah, I feel
Yeah.
it's like I feel like you get the message a little bit late, but yeah, you were out for maybe 30 seconds, but you're
Okay,
back.
when he confronted her thinking she was responsible, she began driving like a maniac, and actually, I think for the first time, made him start questioning her more and made him start fearing for his life. And this was around the time that she claimed to be pregnant. Then Mike was convinced by Mike Stanley to sign the house over to Dalia 100%. On the 31st, Mike signs the house over, July 31st. And that's when the attorney tells Dalia, well, he's still going to have to sign for you to do anything because it's a marital residence. And this is Florida, it's a community property state, even if only your name is on the title. So that's when Mike's life developed a firm expiration date in Dalia's mind.
Mhm. Yep.
So she goes back to Muhammad. At one point, she offered Muhammad $5,000 to buy his gun or to buy a gun for her. And she also tried to steal a gun from Muhammad's car, which we didn't talk about last time. The things that Dalia did over the course of these 4 or 5 months are there's so many different things. It's hard to keep track of them, and it's hard to keep a chronology or make a
Yeah, she's such
chronology.
a hot mess. It's hard to keep track of it because she's always doing something crazy.
Um,
Yeah. To her credit, she always goes to 11 whenever she doesn't do anything halfway.
yeah. And well, the other funny thing is her ability to deny and ignore, and her attorney's ability in this case to deny and ignore all these things that all point toward she wanted to hire a hitman to kill Mike. That totally, without a doubt, demonstrate her intent, and they try to pretend there was never any intent. But we'll get to that later. So then on the 31st, after she's reached back out to Muhammad, she's tried to steal a gun. She's told him she tried to poison Mike and it didn't work. Muhammad realizes she's dead serious and he doesn't want anything to happen. He doesn't want to be implicated in anything. So he goes to the Boynton Beach Police Department. On the 1st of August, he calls Dalia at the request of BBPD. This is when Dalia is identified by police. They meet at a mobile gas station.
And Lisa, your connection went out. Oh, and you're back.
And I'm back. Okay. They met at a mobile gas station, and that is when her identity and Mike's identity were finally confirmed by Boynton Beach Police Department. So when Muhammad first came to them, they didn't know who Dalia or Delilah, he was calling her Delilah. They didn't know who she was. He didn't know her last name. He didn't know where she lived. He didn't know her husband's name. He knew nothing. So it was only after Dalia met him at the mobile station that they were able to get the license plate for the vehicle she was driving to find out where she lived. They got her phone records and her phone number, so they got her name. Dalia also is one of those people that had two phones. She had one phone that Mike had the number for that was her realtor phone, and then she had the other phone for her escort business.
Crazy phone. Was she an
But she
escort
was
while they
still,
were married, or did she retire?
yes, she was still an escort because at the first trial there was evidence that she was still servicing clients during that time. And if you can find her first trial on YouTube or Court TV or anywhere, there are some amusing text messages. Poor Alex Marino had to read the text message. I think at the third retrial he had to read all the text messages as well. So anyway, so then on the third, Dalia meets with Woody Jean, who's posing as a hitman. Now he had called her. He wanted her to bring key to her house, her alarm code, and $3,000 to this meeting. She immediately calls Muhammad. She's aggravated because she thinks $1,200 is going to get the job done, and then she'll owe him on the back end. And, that's the deal she thought Muhammad gave her. And so she's kind of aggravated. And then she goes to the meeting. She doesn't have any of these things, but she also has an alternative plan of killing Mike at the bank when he has $10,000 on it. So she wants Mike killed at the bank when he can pay for his own hit. Then she meets him. They do the recording. He pretends to think the bank is a really good idea, and he says he's going to investigate it, but he calls her subsequently, either on the 3rd or the 4th, and says, no, that's not really going to work. And so be out of your house tomorrow morning at 6 o'clock. At 6 o'clock in the morning, she leaves the house to go to her gym, carrying all her jewelry in her Prada purse. In spite of the gym saying, don't leave valuables in your car, because they have had car burglaries in their parking lot. And while she's gone, BPPD sets up the fake crime scene and then advises Mike that Dalia has hired someone to kill him. Now, there has been some criticism of BPPD of not informing Mike on the first. However, it makes sense. They don't want Mike to distance himself from Dalia or act any differently with Dalia, or perhaps even say, I know you're trying to find somebody to kill me. That could put him in danger, or it could theoretically put her in danger as well. And if he didn't abuse her, but he finds this out, he would have a good reason to abuse her. And let me just say that too. I do not believe her allegations of domestic violence, because if you read the text between her and Mike Stanley, they appear to be entirely fabricated. They do not appear to be based on fact. And Dalia has told Muhammad he's such a sweet nerd and would never lay a hand on me, but I hate his guts. So that is why I do not believe that she was ever abused by Mike Dippolito, nor do I believe that he really would have. Although finding out she's trying to hire a hitman to kill him might push him over the edge. I don't know. So she is brought back to the fake crime scene, taken to the police station, questioned by police, and then arrested. When confronted with the fact that they have everything on video, that they have her meeting with Woody Jean on video, that they have the confidential informant and the meeting on video for that, and then giving them $1,200. She says, I didn't do anything. I didn't do anything. She calls Mike from jail, and she tries to convince him that she didn't do anything, that everything he heard was fake. It wasn't true. I wouldn't do that. I would never do that to you. I love you so much. Boo hoo hoo. But when he offers to go ahead and help her, if she signs the house back over to him, she changes and turns to ice. I'm not signing your house over, and I can't believe I'm in this position and you're worried about your house. And then she immediately calls her mother and tells her mother she wants him out of the house now. So, okay, on the 6th and 7th, Mike files various legal actions against Dalia, including for dissolution of their marriage, to protect the house and keep her from doing anything with the house. Dalia is released on bond to house arrest at her mother's house in Boynton Beach on August 6, 2009. I'm not going to go through any of the legal proceedings for the first trial because it's really not, I don't want to replow that ground, but she was tried in 2011, convicted and sentenced to 20 years in prison. She was released on post appeal bond. And then in 2014, her conviction is vacated and her case is remanded for a new trial. She and Mike were finally divorced on October 6, 2011. The state sought a rehearing of the 4th District's ruling, and that was denied on August 27, 2014. The proceedings begin for the new trial. Mark Eiglarsh and Brian Claypool, who are basically two TV attorneys from HLN, have taken on her case, and they have this strategy of basically attacking the Boynton Beach Police Department and their investigation because of the involvement of cops, which was not aired until after Dalia was convicted in 2011. And so they end up filing a motion to dismiss based on objective entrapment and egregious conduct of the Boynton Beach Police Department that violated Dippolito's rights. In November of 2015, there were 2 hearings on January 19th and February 23rd, the one at which Dalia committed perjury. And post-hearing briefs were filed on the 29th. Dalia filed a motion to reopen, which was denied on the 29th. The judge denied the motion to dismiss on March 2nd, 2009. The judge also issued an order to show cause to Brian Claypool as a result of comments he made at a press conference on February 23rd, 2016, which essentially said, if the court follows the law, he's going to dismiss the charges. If he follows a publicity, he's not going to dismiss the charges, which is improper.
All right.
On March 18, 2016, Dalia gave birth to a son who was conceived while she was on house arrest. The father, as it turns out, as we later found out, is a convicted felon who apparently had been living with the family. On April 4th, 2016, Dalia filed a petition for writ of prohibition at the 4th District Court of Appeal seeking an order to prohibit her continued prosecution. On May 5th, 2016, the trial court had to cancel future dates pending this decision on the writ of prohibition. On August 17th, 2016, that writ was dismissed by the Court of Appeal. On the 29th of August, she filed a writ with the Florida Supreme Court. On the 13th of September, an amended scheduling order was filed setting trial for December 1st, 2016. And on October 18, 2016, the writ of prohibition was dismissed by the Florida Supreme Court, or they just declined. They declined to hear it because it had already been heard by the 4th District. Now, so a couple things we didn't talk about in the last episode. 2020 episode aired on December 4th, 2015. It was called The Woman in the Video, and it was basically a defense propaganda piece.
I remember seeing that, I think.
Which included, Claypool and Eiglar, or Claypool mostly, giving this, they entrapped her, they created a crime to be on cops, blah, blah, blah. And it included a sit-down interview with Dalia. And then pre-trial, the case went back to the Circuit Court of the 15th District of Florida in Palm Beach County. The judge was the Honorable Glenn Kelly. It was in Felony Division W, or Division W. Some different pleadings have different designations. Her attorneys were Mark Eiglosh, Brian Claypool, and Greg Rosenfeld had been brought in as local counsel. State was being represented by Craig Williams and Laura Laurie. The state filed a motion for revocation of bond on March 7th, 2016, seeking to revoke Dippolito's bond on the grounds that she had permission to travel to her attorney's office in Miami for trial preparation, but did not get permission to travel to Miami or move about the streets in Miami to appear on a television program.
Shocking.
On the 20
I mean, she's just a mess.
Well, her attorneys claimed that it was their advice.
I'm sure
that,
it was.
You know, it was on their advice that she traveled to Miami because they considered this interview, this day to be trial preparation day, even though part of it included an interview with Amy Robach. So, and she was also not supposed to be walking around the streets of Miami. And she was walking around the streets of Miami. On the 22nd of March, the judge granted the motion in part and denied it in part. Dippolito was allowed to remain on house arrest, but she was not going to be allowed to travel to Miami-Dade County to meet with her attorneys, but she would be allowed to travel to Rosenfeld's office. He was in Boynton Beach or Palm Beach County to meet with attorneys there. On the 13th, as I said, there was an amended scheduling order setting the trial for December 1st, 2016, and hearing on motions for November 30th, 2016. On October 24th, 2016, Eiglosh filed a motion to withdraw based on an undisclosed conflict with Dippolito. This is my speculation. I believe that after the motion to dismiss failed and the writ of prohibition failed, that Eiglosh felt they should seek some kind of deal with the state attorneys for a guilty plea and a negotiation of a sentence that might see her serving a couple of years in DOC and then being released.
But not, yeah.
And I think that probably Rosenfeld and Claypool did not see the failure of the motion to dismiss and writ of prohibition as a stumbling block in the new trial. And so they were going to go with that same theory at the new trial. And Eiglosh did not agree with that. And it turns out if that was the undisclosed conflict, Mark Eiglosh was right. I've always liked him a little bit better. I've always hated Brian Claypool. Okay. Brian Claypool is just, I've always hated him. Even if he agreed with me on a position in a case, I've hated him. On the 26th of October, Dippolito filed a motion for continuance. I didn't really look at that to see what the grounds were. I wanted to, I meant to, but I didn't. My apologies. It may have had something to do with Eiglosh's withdrawal. But I'm sure if it did, the order denying the motion to continue said, you've got 2 attorneys. You don't need 3. The court granted the motion to withdraw and denied the motion to continue on October 27th. The court sua sponte, which means the court took action on its own, filed an order invoking plan for special interest, high-profile proceeding on November 14th, 2016. And that basically just sets guidelines for the parties and guidelines for the court and guidelines for court administration on media. And it's like a 10 or 13 page standing order that if you want to read it, it's available on the Palm Beach County website and you can read it for your own education, but it's not something I need to go into here. Motions in limine were filed on November 25th, 27th, and 28th. And basically, the defense was seeking to exclude video of the staged crime scene, references to Dippolito as an escort, the references to attempted poisoning, the stage crime scene, which was amended, and then video of Dippolito at Boynton Beach Police Department and her prior bad acts. They also filed a motion to dismiss on November 29th, 2016, which they sought to either dismiss the charges or to exclude evidence, which would be a lot of the recordings of Muhammad and Witty Jean with Dippolito, or for spoliation instructions and for additional peremptory challenges. Basically, they were arguing that there was a recording of whatever happened in Chili's, and that because it was exculpatory, Boynton Beach Police Department destroyed it, but they never really proved that. That was just their claim. But they fell short of proving it. They also filed a motion for individual voir dire on the 30th. That may have been an oral motion that they made at the hearing. The hearings were held on the motions in limine and the renewed motions to continue and dismiss and for additional peremptory challenges. The motions regarding Dalia as an escort, poisoning, and staged crime scene were uncontested, so they were granted. The renewed motion to continue and motion to dismiss were denied. Additional peremptory challenges was also denied, and the motion to dismiss or exclude evidence and testimony or for spoliation instruction based on failure to preserve, loss, or destruction of evidence was also denied, but that was without prejudice, so they could re-urge it if they were able to prove through testimony or evidence that there was a destruction of exculpatory material. They could re-urge that motion.
Gotcha.
And then the court reserved ruling on the motions in limine related to video of the defendant at Boynton Beach Police Department and prior bad acts, and the motion to suppress video of Shahade at the mobile gas station. Now, this is interesting. They were trying to argue that they didn't have permission to videotape or record Muhammad Shahade at the mobile gas station because he didn't sign a release. But there is a release within the confidential informant packet. But when they said, did you give permission? Muhammad Shahade said, no, I didn't want that. So again, what Claypool and Rosenfeld did through most of their defense of Dalia Dippolito is they ignored a mountain of evidence and continued to re-urge their little nuggets of bullshit.
Well, that's what they usually do, right? I mean, that's all these guys, right?
I have found that this is one of the more egregious instances because, in my opinion, and I know it's only my opinion, they lied to the jury and they lied to the court and they lied in pleadings multiple times. The motion to dismiss and all the stuff about cops, that was a lie because cops was not involved in the investigation from July 31st through August 4th. They only were involved for a small part on August 5th. And the investigation, that was the conclusion of the investigation. And they also tried to say that the Boynton Beach Police Department invented the crime, the murder for hire, to be on cops, when the reality was that cops doesn't require departments to bring them stories. Cops' usual format for decades was following officers on patrol. And they might have days and days of little to nothing happening worth airing. You know, they would probably have hundreds of hours of footage to go through to come up with a block of episodes in a jurisdiction. And there's also the fact that they ignored that cops had at least one instance where the footage took during an event while riding along with police never aired, will never air, because it involved the death of officers and a suspect, and I believe personnel from cops in a shootout in, I think it was Kansas City, Missouri. And this was around the same time as the Dippolito case. So cops is not looking for salacious stories.
Right.
So anyway, okay, so off my soapbox before I fall off and break my ankle. So 2016 retrial, and I know there's a lot here, but I'm just going to kind of hit the highlights. That was in the same court. Craig A. Williams and Laura Laurie were the attorneys for the state. Claypool and Rosenfeld were representing Dippolito. They did jury selection. That took 2 days. On the 4th, they argued motions to change venue and motions to exclude all video and audio recordings of Shahade and Dippolito. There was a hearing. They put on evidence at the hearing, and the motions were all denied. They actually went into J3 of jury selection on December 5th. They filed a renewed motion for change of venue on the 6th, which was denied. Excuse me. And then they had,
Lisa?
Nope. Oh, I had a cough. So maybe it's fortuitous that I was lost.
Oh, and I think Lisa has.
Nope.
Maybe.
I'm back.
Oh, you're back.
I'm back.
Guess
Okay.
who's back?
Oh, and now it's gone. And now now it's back. Now it's gone. Okay. Am I back?
You're back.
Okay. They finally, on day 4, selected a jury. Florida is weird. For felonies, they have 6 jurors. The only time they have 12 jurors is if it's a capital case.
Oh, okay, got it. That's right.
And,
I think I remember that.
And it's interesting that nobody has ever challenged this composition. I'm frankly surprised that Dippolito's attorneys did not throw this one at the wall to see if it would stick, especially after Ramos with the non-unanimous verdicts. But they didn't, and it's too late now. But they've picked 6 jurors. The defense argued a motion to sequester the jury, which was denied. They re-urged their motions in limine, which were denied. They filed another motion to suppress on the 7th, which was denied. The jury trial began, and the mistake that the state made in this jury trial was that they pared down their presentation for their case in chief. They did not call Mike Dippolito. They did not go into the weeds with the text messages between Dippolito and Mike Stanley. They did not go into a lot of the theft of money from Mike Dippolito, the transfer of the house. I mean, it was really a very pared down presentation. And I think a part of that was because the video and the audio in and of themselves prove the crime of solicitation to commit first-degree murder with a firearm. And I think that they maybe didn't want to subject Mike to Brian Claypool's bullshit. And so they did this pared down presentation, which concentrated on the solicitation, the events of the solicitation, beginning with Shahade and ending with the staged crime scene. Then the state rested, and the Dippolito argued a motion for judgment of acquittal, which was denied. And then the defense put on their defense, and they bring in all these Boynton Beach police personnel who testify, quote, for the defense. And in some instances, I think that the state did not really do a great job of turning those witnesses into state witnesses when they were cross-examined. There were a couple that they did, but a couple that they really just didn't give it their all. So the state did seek to reopen its case, and that was granted. Dippolito had a police expert testify. Dippolito elected not to testify and allocated on the record before the judge, which is to keep it from saying, I wanted to testify, but my attorneys wouldn't let me down the road. And then the defense rested. The state had a rebuttal and sought to reopen the case, but the only thing they did was they played the staged crime scene video that was actually posted by the Boynton Beach Police Department. And then they had Stephanie Slater and Moreno testify. The defense again re-urged several motions to dismiss and suppress and for judgment of acquittal, and all those were denied, or rulings were reserved by the court until they ultimately denied them. And they also argued a motion to dismiss on objective entrapment, and that was denied. Now, just to go into subjective entrapment means you admit to committing the crime with which you're charged, but you argue that the police got you to commit the crime that you wouldn't have otherwise committed. So, or
Wait, can you say that one more
informant.
time? I want to make sure I'm following you.
Okay, so basically, you're saying when subjective entrapment, yes, I committed that crime, but it's only because the police put me into position to commit it. Or an informant, like if an informant is monetized and offers you a bag of money to transport drugs, most people are going to do it, even though otherwise they would say, no, I'm not going to do that. And they're, you know, I wouldn't do it for nothing, but I'll do it for a bag of money. But you have to admit your guilt to the underlying charge. And then the actions of the police or their informants becomes a mitigating factor that you wouldn't have otherwise committed the crime but for the conduct of the police or the conduct of the informant. Objective entrapment is basically an argument that the conduct of the police was so egregious that you didn't even commit a crime. You know, but that's an issue of it's an issue of law to be decided by the court, not an issue of fact to be decided by a jury. So there's a separation. And the motion to dismiss partially was based on objective entrapment, that they created a crime where none existed. That she was just a domestic violence victim, and Muhammad Shahadi was trying to get help, and they saw the opportunity to make her try to hire a hitman. And so they moved her into position to try to hire a hitman. So that was that. Closing arguments were held, and you know, again, Claypool, everybody's a liar but Dalia. Everybody did wrong but Dalia. And he even made an improper statement toward the end of his closing argument, telling those jurors to send her home to her infant son. The jury was charged. The alternates were excused. Jury instructions were read, and deliberations began. Now, during deliberations, which were conducted between December 13th and December 14th, the jury sent 4 notes out to the court. And what's interesting is the content of the notes actually kind of tells me why it resulted in a mistrial. The first note, they wanted to know if they could get copy of all transcripts of the video and audio phone calls, and a copy of Shahade's original statement and recording? And I believe the answer to that was no, because they weren't entered into evidence. Can the jury re-listen to all the audio and video and date to be able to stop and pause as necessary in a number order? And I believe that was allowed, and the audio was replayed. A lot of the audio was difficult to hear or difficult to understand. And the state had produced some transcripts, but they didn't have a court reporter produce and certify the transcripts. And so there were errors. They probably had somebody like me listen to the transcript and type it out.
Right. Gotcha.
To the best of her ability. But there were errors. And, that happened. So it ended up where the state could not use those transcripts. The audio was not good quality, hard to hear, hard to understand. There was one point where Shahade was so fucked up on Xanax that you couldn't understand what he said. He was, he just mumbled. And so you had Dalia's half of the conversation and Shahade mumbling. Then note 3, the jury first said they feel they cannot come to a unanimous verdict. There's a thing called an Allen charge, which is basically asking the jury to go back and continue deliberating and try to work out their differences. One of these days, I'm going to get the text of the Allen charge, because I think it's pretty much the same because it's a Supreme Court case, whatever state you're in. And after that, they went back and deliberated, and note 4 said, we, the jury, want to know if there's any other charge that we can consider. If the answer is no, the jury still feel we cannot reach a unanimous decision on charge. So I think what happened was 3 were solidly guilty on solicitation to commit first-degree murder with a firearm. 3 knew she committed some crime, but didn't think it was that crime. And so they ended up playing the tapes again. I think I have that in the wrong place. The defense moved for a mistrial, which was denied at that point. And then note 5 said, we, the jury, after further deliberations, cannot reach a unanimous verdict. So a mistrial was declared on December 14th. 3 were guilty, 3 were not guilty. Then they sought to modify conditions of pretrial release. On January 2nd, 2017, they wanted to relax Dalia's restrictions and expand her freedom while on house arrest, letting her travel to a park with her child, to have more access to her mother's backyard and the mother's property, to be able to go to church more often, to be able to go to the grocery store, everything like that, and kind of arguing, look, she's been convicted, but now she's got a mistrial. So, we're kind of 50-50. There was a hearing on January 6, 2017. The motion to modify conditions of release was denied. And then they also set a deadline to respond to the state's request for change of venue, because I think their knee-jerk reaction, I don't know exactly when it was filed because it's not on the docket, but I think the state's knee-jerk reaction after the mistrial was maybe we need to move it out of Boynton Beach.
Yeah, it makes sense, I guess.
And there was in 2016 there were some anti-police incidents and campaigns.
Yeah, because really after 2012 is when a lot of that stuff really started.
Yeah,
right?
and I think 2015 was the Baton Rouge guy selling CDs outside of the convenience store, that police came to the store just kind of see what he was doing, and he bowed up on him, and they ended up shooting him when he resisted
Right.
their efforts to put him into handcuffs. I don't remember when Eric Garner was in New York. It may have been earlier. I think Eric Garner was kind of the beginning.
Or no, it was who was it? Michael Brown, right? The guy in Ferguson, Missouri, right? Was he before Eric Garner?
They might have been around the same time. I
Seemed
think
like
he
they
was
were
in
pretty close.
2014.
Yeah.
Yeah, I think he was like 2014. But anyway, there had been, and I think at the time of the trial, there was some local incidents in Palm Beach County that led to anti-police sentiment. And the defense was capitalizing on it.
Right.
So there was a hearing and order issued on the 13th of January. Basically, news of Dalia's baby spurred media interest in the media, sought records to find out when the baby was born, where the baby was born, when the baby was conceived, try to kind of do the math to figure out, how this happens when somebody's on house arrest. And I don't blame them. And so the court was going to look at the in-house arrest records because I think they wanted to see how much of the in-house arrest records could shed light on the questions that, the public want to know.
Yeah.
And the court is going to do an in-camera inspection. Then another order was issued canceling the deadline for the response to the state's request for change of venue because the state had withdrawn that. A scheduling order was issued on January 19th, 2017, setting the trial for June 2nd, 2017. Motions in limine were due May 17th, and hearing on the motions in limine were set for May 24th, 2017. An order was entered declaring Dippolito indigent for costs on January 27, 2017. The attorney stated in the motion that they were representing her pro bono. They wanted her declared indigent for cost. They also made requests for $400 for transcripts of the hearing on January 6, 2017 on the motions to reduce bond, motion to modify bond or conditions of release rather, and $10,000 for transcripts of the November 30th hearing and jury trial from December 1st to December 13th to prepare for the retrial. It also granted the request that state and local agencies waive their customary fees. And that means basically if they go to Boynton Beach Police Department seeking police reports about Mike or Dalia or Shahade, that the Boynton Beach Police Department won't charge them fees. Florida Department of Law Enforcement won't charge them fees because she's indigent. And then also ordering that any future cost requests be made by motion. These are not ex parte. I believe they're open. So the state knows that they're asking for the money. And then they filed a motion for protective, or the state filed a motion for protective order and revocation of pro hoc vice status on February 1st, 2017, based on Claypool's media activity and portrayal of the case to the media, including continued claims that the crime was manufactured by the Boynton Beach Police Department and that the prosecution was politically motivated. There was a hearing on a second motion to modify pretrial release on February 2nd, 2017. That was denied in part and granted in part on February 7th, 2017. Basically, Dippolito was granted permission to attend her brother's wedding events, and she was granted full access to her mother's property, including the full yard. She wasn't allowed to go to the park or the grocery store or have any further contact outside her mother's house, but for scheduled attorney visits in Boynton Beach. Claypool filed a response to the motion for protective order and to revoke his pro hoc vice status. And you're not surprised, I'm going to say it was it was pure bullshit. February 13th, 2017. And I could not even bring myself to type any of the bullshit because it just incensed me so much. Because what he and Rosenfeld would do is they would say these things and do these things, and then when they're confronted by the court or by the state with having said or done these things, no, that's not what we meant.
That wasn't what we did. Yeah.
That's not what we did. We did not do that. I did not do that. I did not say that. And they also portrayed the attempt by the state as an unfair attempt to gag them while leaving the state open to, you know, try its case in the media, which the state wasn't doing. I mean, if media people were showing the videos of Dalia with Muhammad giving him $1,200, that's a media's choice. The state's not getting that to be done.
Right.
It's just these media people in Palm Beach know the case and they know what happened. And they're not buying your bullshit.
Which is rare because they usually always do buy it of the people that are convicted.
They usually do, but this particular case, Dalia did not become Mother Teresa and people did not like her. People continued to dislike her. When you go find the YouTube videos of the different trials, even the mistrial, the 2016 retrial, those people are vicious. I mean, vicious. And I don't think there's a single pro Dalia comment. And if there is, the person is shouted down in the replies. So the state filed a reply in support of the motion. And there was a hearing on March 3rd, 2017 on the motion. The court issued an order on the state's motion for protective order and for revocation of pro hoc vice status on March 17th, 2017. And I want to go through this because later on, they take this bullshit up to the U.S. Supreme Court. So I want to go through what the judge found. His factual findings: the case has garnered extensive media coverage since Dippolito's arrest, due in part to the involvement of cops. There was extensive media coverage of the first trial, particularly at the local level. Elizabeth Parker, the prosecutor from the first trial, authored a book about the case. This publicity all predated Claypool's involvement. Claypool's participation in the case took the publicity to a new level. Claypool conducted numerous scheduled press conferences to discuss the case and the defense's version of the facts leading up to the retrial in December of 2016. In early 2016, Claypool conducted regular press conferences discussing his view of the facts of the case and the significance of those facts prior to the court hearing the motion to dismiss. Most of Claypool's comments focused on the Boynton Beach Police Department and the defense theory that the police manufactured the alleged crime for the sake of an appearance on cops. The court issued a show cause order to Claypool based on comments made in one of those press conferences on February 23rd, 2016, immediately following an evidentiary hearing on the motion to dismiss. The court concluded that Claypool's statements violated Bar Rule 4-8.2a concerning the integrity of the court that he knew to be false or that was made with reckless disregard as to its truth or falsity. And Bar Rule 4-3.6a, making statements that he knows or reasonably should know will have a substantial likelihood of materially prejudicing an adjudicative proceeding. And one of the comments the court made is it's obvious from these actions that Claypool is trying to influence the jury pool. The court decided against revoking Claypool's privilege to appear in the case after a hearing. Media coverage of the second trial was extensive and pervasive. Stories regularly appeared in the printed press, including Palm Beach Post and Sun Sentinel. All local television stations covered the case. National news media, including Dateline, were present in the courtroom. The case was discussed on nationally broadcast news programs like ABC's Good Morning America. The trial was live streamed and could be viewed nationally over the internet. The impact of this news coverage on the retrial cannot be overstated or ignored, and jury selection was affected by the pervasive media attention. The defense repeatedly moved for a change of venue, asserting that Dippolito could not receive a fair trial, in spite of the fact that Claypool was commenting about the case on a Twitter account. After the mistrial was declared, Claypool again conducted a press conference to discuss the case and continued to discuss the tactics and motivations of the Boynton Beach Police Department and commented on the spiritual nature of defendant and her family. The case has continued to receive extensive news coverage, at times featuring comments by Claypool or his co-counsel Rosenfeld relating to the case. Counsel's comments have recently moved criticism of the state attorney's office, including a press release in which Dippolito's attorneys are quoted as saying the prosecution is politically motivated and that taxpayers should not have to bear the cost associated with prosecutions trying to save face. The same article references the sentencing guidelines and asserts that Dippolito has already done her time based on the nearly 8 years she has been on in-house arrest, which legally don't count. The court must decide based on the history of the case whether Claypool's pro hoc vice status should be revoked and or whether counsel should be prohibited from continuing to make extrajudicial statements concerning this case. So the court ordered the motion to revoke pro hoc vice status was denied, but a protective order was granted, and all counsel were prohibited from making any extrajudicial statements that a reasonable person would expect to be disseminated by means of public communication concerning or related to the evidence in the case or any party's view or opinion of it, the facts of the case or any party's interpretation of them, including inferences that could be drawn from those facts, the motive or motivation of the state in prosecuting the case, or the motive or motivation of the defendant in pursuing any theory of defense, sentencing or punishing of the defendant, including any reference to the sentence imposed after the first trial, theories of the case by the state or defendant, the first or second trial of the case, including the results of those trials, and disparagement of any attorney of record in the case. Nothing in this order shall prohibit attorneys from commenting generally on the progress of the case, procedural matters, or rulings of the court, provided the comments are consistent with the Florida rules of professional conduct. Unless specifically renewed by the court, the prohibitions contained in this order shall automatically expire upon the swearing of a jury to hear and decide this case. Now, that is a reasonable order, and as you heard, the judge's findings and reasoning were impeccable. And it wasn't one-sided because it applied equally to both prosecution and defense.
Well, and that's always an important thing. Like that's why it's a good way, I think, as a layperson to say, hey, this is a fair ruling if it equally applies.
Yeah.
Pardon me.
So on March 21st, 2017, Shahade was found unconscious in a motel room in Boynton Beach with a dead woman whose cause of death was determined to be a drug overdose. Shahade was hospitalized for treatment for a drug overdose. The matter was investigated by police. He wasn't ultimately charged. There was a motion in order to show cause filed on March 27, 2017, and then another motion was filed on the 29th of March by Dippolito, alleging that the state or Elizabeth Parker told the media that Mike would be called to testify at the third trial. Now, if Elizabeth Parker told the media, she was not enjoined by the protective order. So if she, again, so much bullshit, so little time. I did not really memorialize all of their claims or how they claimed. And it probably was, knowing Claypool and Rosenfeld, 97% speculation with 3% actual fact thrown in. But I didn't even read the articles. So how Mike's testimony, but I believe, and I said they should have had Mike testify at the second trial. If they had had Mike testify at the second trial and gone through those text messages with Mike Stanley, she would have been convicted. The jurors would not have been debating the charge. She would have been convicted. Because what she did to Mike provides the context of the crime she committed. So, you know, and Mike testified at the first trial, she was convicted. Mike testified at the third trial. Spoiler alert, she was convicted. So there's a correlation there.
Exactly.
Why
didn't they have him testify? Do you know?
Well, I think, like I said, it's my speculation. This is my opinion. I think the state felt the crime occurred in the conversations with Shahade, in the videos, the conversation and video with Woody Jean. And so they didn't need Mike. And they didn't need the text messages. And they were trying to pare it down. And I think that they were trying to pare it down because that would limit cross-examination of state witnesses during the state's case in chief. And it would probably, they thought, to a degree, limit the defense evidence during the defense's case.
Gotcha.
Even though I think, you know, Claypool lied. Claypool has said Mike Dippolito's crimes were committed against old people, which isn't true. They were contacting investors. Some of them may have been over 65, but they were people who had a lot of money that Mike wanted, or Mike and his co-defendants wanted. They weren't all old people living on fixed incomes.
Right.
And none of the charges against him involved crimes against elderly people. Although in 2009, that might not have existed. But now, when you commit a financial crime against an elderly person, that is a felony charge in and of itself in most states. So anyway, so yeah, I think they were trying to insulate Mike from that. Mike was shocked that he wasn't called because he expected to be called.
Yeah, it seems like he would be. It's crazy.
So, and then, you know, there were additional costs awarded for the transcripts of the two hearings on the February 2nd and March 3rd. And on March 3rd, because Dippolito was going to appeal the gag order, there was a hearing on April 5th, 2017, where the order to show cause was denied because it was bullshit. It's my opinion, but that's what I'm gonna believe.
The technical time.
If they can live outside reality, so can I.
There you go.
Additional costs for that hearing transcript were awarded on April 6th because they probably were contemplating appealing that. Again, the court issued the order invoking plan for special interest high profile proceeding on May 9th, which is out of order because I added it in and I added it in the wrong place. Sorry. On April 24th, May 16th, and May 17th, Dippolito filed the usual motions for additional peremptory challenges for motions in limine regarding escort, poisoning, prior bad acts, staged crime scene, which was a second amended motion to exclude defendant at Boynton Beach Police Department, exclude that defendant researched funeral homes, and exclude that defendant tried to steal a firearm. So I think the defense sensed a disturbance in the force that meant that the prosecution was going to call a lot more witnesses and go into a lot more things when it did this retrial. So they were trying to keep evidence out. And if, you know, like I said, if they're right, then why don't they want the jury to hear about all this evidence? I mean, they're claiming she was a victim of domestic violence. So spin the theft of the firearm as to try and kill herself, which they did eventually try to do once the horses were out of the barn. State filed a motion in limine to exclude various things. Some of them were general things that all motions in limine and criminal prosecution seek to exclude. And some of them were probably specifically based on what Brian Claypool did during closing arguments and the trial for the 2016 retrial. So reference to possible penalties, references to witnesses not called by either side who could have called them, validity of the arrest, reference to the fact that the defendant had never been arrested or convicted of a crime or a felony, reference to use of hypothetical questions during voir dire with the intention of obtaining commitment from jurors. And I think that's because during voir dire, Claypool tried to go on the offensive against Point Beach Police Department. Exclude any references or overt attempts to obtain a jury pardon. A defendant has no constitutional right to request a jury pardon. Jury pardons are by definition a miscarriage of justice. Jury pardons are also called jury nullification. And I think that's basically also what happened in the 2016 trial. 3 jurors took Claypool's nullification statements about sending a message to law enforcement and tried to do so.
Went too far.
Yeah. Let's see. Any mention of statements by the defendant which might indicate remorse, which we don't have because Dalia Dippolito says she didn't do anything wrong.
Yeah, no remorse.
Any reference directly or indirectly raising a mental health defense, including but not limited to testimony or arguments concerning defendants' diminished mental capacity or marginal intelligence. And that's because of the battered women syndrome and post-traumatic stress claims that they were trying to get in through their battered women's expert. Excluding reference to police misconduct, which does not involve the police officer testifying. Let's see. I think that's pretty much most of them are kind of general. Some are related to Claypool's many misdeeds during his closing argument in 2016, but the last one is exclude or any argument to send a message to law enforcement across the country suggesting that the jury could not follow the law and judge the facts of the case, but rather provide an impermissible jury pardon. Any comment to the jury to send the defendant home to her infant son, which is also improper. State's motion in limine, they filed a second motion in limine to specifically include evidence or testimony that Dippolito was suffering from battered women's syndrome or was susceptible to coercion by Boynton Beach Police Department due to battered women's syndrome or PTSD. They were awarded additional costs for transcripts of depositions taken on May 22nd. The hearing on the motions in limine were held on the 24th of May. Basically, the defense didn't take any action on its second amended motion to include video of the staged crime scene, so that was left undecided. The motion in limine regarding escort, poison, and funeral homes were granted. Now, that does not mean that those topics cannot be brought in should circumstances arise. It means the state can't bring that evidence in during its case in chief. If the defense brings a witness in that says something, if Dalia Dippolito gets on the stand and testifies, I was never an escort, they can bring that in. If another witness testifies, I didn't believe she intended to kill her husband, they can bring the poisoning allegations in. So it doesn't mean that they're forever excluded. It just means the state can't bring them into the case in chief.
Gotcha.
The court denied the renewed motions to dismiss and actually said they are not to be relitigated. A motion for individual voir dire was denied. Motion in limine on the attempt to steal a firearm was denied. Basically, the court was going to decide if it was admissible at the time, if the state chose to admit it. And then motion for 6 additional peremptory challenges were denied. The court granted in part and denied in part the prior bad act motion in limine and the prior attempt to hire Larry, which is the Riviera Beach attempted hitman hiring, and it denied part of the state's motion in limine and granted part of that motion in limine. And again, a lot of times motions in limine, even topics that are denied, can be re-argued at trial on the fly. If the state believes something that was granted should be let in, they can argue to have it admitted. If the defense feels something that was left out can be admitted now, they can argue that. And the defense's motion to include video of the defendant at Point Beach Police Department was denied in part and granted in part. And then the court reserved ruling on the state's battered women's motion in limine and the second amended motion to exclude videos of defendant at Boynton Beach Police Department, meaning that he would rule when the appropriate time came at trial. The additional costs were awarded on the 25th, granting money to obtain transcripts of the closing arguments on December 12th and December 13th. And also another thing that is important for people to recognize is that a lot of state, quote, costs are spent in indigent defense.
Yep. No, for sure.
So if you want to complain about costs, then don't be asking for $10,000 for expedited transcripts.
Right.
Just saying. On May 26, 2017, Dippolito's writ, I don't think this was an appeal. It was a request for review. The gag order, it was a certiorari request to the Fourth District Court of Appeal. A decision was entered. The denial of defendant's petition seeking certiorari review of the trial court's order prohibiting all attorneys in the case from making extrajudicial statements until the jury is sworn for the defendant's third trial was proper because a well-reasoned order did not depart from the essential requirements of the law. The order demonstrated that extrajudicial statements posed an imminent and substantial threat to a fair trial, was narrowly tailored in both substance and duration, and was viewpoint neutral as it applied to extrajudicial comments by both parties' counsel. So the petition for review to the Fourth District was denied. Not happy with that, Dippolito also sought review at the Florida Supreme Court at around this same time. I don't have that on my thing because I didn't look at the docket on the Supreme Court website in time, and that's on me. Motion in limine to preclude testimony by Dr. Lenore Walker was filed by the state on May 30th to prevent battered women's syndrome from being made a part of the trial. And then motion in limine to preclude testimony by Susan Constantine Perfido was also filed by the state, seeking an order prohibiting testimony that Dippolito's body language, facial expression, and/or verbal cues negated her intent to commit solicitation or first-degree murder. Responses to the state's motion in limine were filed on May 31st, 2017, and as you can see, I didn't have the fortitude to even bother because, again, they were 90% speculation and 3% fact. The hearing was held. The motion in limine as to Dr. Walker was granted in part. The court, I think, reserved ruling on Constantine Perfido. It doesn't really say on the event form what happened with Constantine Perfido, although, spoiler alert, she didn't ultimately testify. I'll have to look at I would have to look at the transcript of that hearing to see if the court entered an order on the record and then it didn't get transcribed into the court event form or on the hearing notes, which can happen. So the 2017 retrial on June 6th, in the midst of the retrial, the court did enter an order ordering Dippolito to submit to testing and examination by the state's expert to allow the state to address Walker's proposed testimony regarding Dippolito's alleged mental and emotional condition, including claimed battered women's syndrome and PTSD, as a result of years of abuse, not only by Mike, but by her father and probably every man who paid her for sex.
Wasn't that like, didn't Casey Anthony claim that basically every man she ever met abused her? I think that seems to be a common.
Yeah, something like that. Yeah, pretty much. Jury selection went for 4 days from the 2nd to the 7th. The 2nd was a Friday, and then I think they did the Monday, 5th, 6th, and Wednesday, the 7th. They swore their jury, and that was pretty much at the end of the day. And then the trial started on June 8th, 2017, and continued through June 16th, 2017. And basically, the lineup was much better. And I'm going to go through it because also during the course of the trial, Dippolito's attorneys were continuing to argue and re-argue the same motions that had been denied in the pretrial phase. They had instructions in jury charge, and then both sides did their opening statements. The state started with the testimony of Mike Dippolito and Alex Marino. They did an out-of-order motion for sanctions and to strike Walker's testimony due to Dippolito's failure to undergo the court-ordered examination by the state's expert. And that incident proves what a douche Greg Rosenfeld is, because the first day that she was supposed to show up, he said, "Oh, I'm so sorry, I forgot, but we can do it tomorrow." And then the next day, he says, "Oh, no, she's not going to be appearing." And then they were trying to say, well, we want Walker to testify to this. It doesn't have anything to do with her mental condition, so you don't have a right to examine her. He's a douche. And I think that's the first time I've ever called an attorney a douche. I probably called defendants that.
Technical term. I'm glad that you can use it.
Yeah. So anyway, so then they argued that motion probably during a break. And then the state continued with the testimony of Alex Marino and Mohammed Shahade. And then the state rested. Now, preface, during Shahade's direct testimony, I think that the limit on cross-examination, they couldn't ask him some of the questions they wanted to ask him because it wasn't brought up in his direct testimony. And they probably were objected to when they tried to bring it up during his cross-examination. So the state rested, and the defense began its case. And so they called a lot of Boynton Beach police personnel. They called Sergeant Ramsey again, and he's kind of like, he's got a sour taste in his mouth because he got in trouble for porn on a laptop that he said his son got a virus on the laptop. But it's your Boynton Beach police laptop. Your son should not be on it.
Yeah, the old it wasn't me. It was somebody stole my login.
And so he was suspended and then reinstated, but I think he had a sour taste in his mouth, so he was a lot more on the defense's side this time, as far as they're trying to go with objective entrapment and egregious conduct by Boynton Beach Police Department. So he's going to help them focus on how the Boynton Beach Police Department treated Mohammed Shahade, and that Mohammed Shahade should have never been a confidential informant. Stephanie Slater, they wanted to just grill her on the staged crime scene and posting the video and how she violated Dalia Dippolito's rights, et cetera, et cetera, et cetera. Then their expert came in and testified about all the phone calls, and that Dalia Dippolito never called Shahade or never called the hitman, that they always called her, that they put these things in her head, that they maneuvered her to commit this crime, and she never had any intent to do it herself. And, you know, she never demonstrated intent to actually kill Mike. And then they recalled Mohammed Shahade as their own witness. And this is where the wheels fell off their little short bus. I know some people are probably going to find that offensive. When I was a kid, it was a bit of a joke. I don't mean to hurt anybody's feelings now, but I still think it's funny about certain people riding a short bus. I'm sorry.
If somebody's offended by that,
It's
they
a
probably
cultural,
shouldn't be inside.
it's a cultural, in my day, it was not, I mean, even the people that rode the short bus thought that there were people that should be riding the short bus with them.
Yeah, it was.
And expressed it.
Sound like the get off the yard old man, but back in my day, we could kind of laugh at one another.
Really. And I don't mean it as, well, I mean it derogatory for them. Because they're of a generation, well, Claypool's definitely of a generation to understand and get that reference. But anyway, yeah, the wheels fell off the short bus because they were so intent on creating their objective entrapment case that they got Shahade to make statements in his testimony that directly were contradicted by his statements to Boynton Beach Police Department in July and August of 2009. And even during his testimony, there were some statements that he made that contradicted what they were trying to get him to say. Because, you know, Roosevelt would ask you were worried about her being hurt. Well, somebody being killed, whether it was her or Mike, I don't know. You know, and so this is why that motion in limine thing comes into effect. And the judge explained this to them in great detail, very patiently, many times during the course of their argument to try and keep this evidence out. You cannot put a witness on the stand and expect the state to let inconsistent testimony go unchallenged. A motion in limine is not set in stone. It only prohibits the state from using the evidence in its case in chief. This is not its case in chief. This is your witness making these statements that are contradicted. They are lies, basically. And the state does not have to let them go. So, the attempt to hire Larry to kill Mike in March of 2009 came in. The poisoning allegation came in because it was based on a statement made by Dalia to Mohammed. Well, I tried to poison him, but it didn't work. And so it was admitted on cross-examination due to Shahade's direct testimony that he didn't believe Dippolito wanted to kill Mike. After Shahade's testimony and cross-examination, and really, it was a mistake to call him at all. If they had left what he could give them when he was a state's witness, if they'd left it alone, they might have given the jury a better opportunity to at least debate her guilt.
Mm.
But they didn't. And in Rosenfeld's direct questioning and redirect questioning, he impeached his own witness multiple times with prior testimony. Because the testimony he gave wasn't good enough. So he's like, well, in this you said. So, and that doesn't bode well for you, because that makes it look like you're getting this witness to lie for you. So Dippolito allocated that she would not testify. They renewed their motion to suppress, which was denied. They renewed their motion for mistrial, which was denied based on the poisoning allegation. Then they rested. They renewed their judgment of acquittal, which was denied. They renewed their motion to dismiss, which was denied. They did closing arguments. During the state's closing argument, they argued another motion for mistrial, which was denied. Then they started alleging that one of the jurors was sleeping, juror number 6. And they made a challenge for cause to her. That was denied. They filed a motion to remove the sleeping juror and affidavits from individuals aligned with Dippolito, including Brian Claypool's brother. The challenge for cause was denied. The defense did their closing, and the state did its rebuttal closing. And then the final jury charges and instructions were given to the jury, which then went out to deliberate on June 16, 2017. There was a single note asking if the initial statement of Shahade and recording were entered into evidence. The answer to that was no. And they came back, I think it was like 45 minutes. They came back with a guilty verdict. And if you can find that on YouTube to watch that, I still to this day love watching that. Because Dalia Dippolito thought she was going to fool yet another jury after the mistrial in 2016. And she didn't. And the look on her face was priceless. And I think she tried to blame her mother.
What did her mother have to do with it?
I don't know. But she looked
That's
back, she's like,
weird.
Mommy.
Man,
So
it's Mother's Day. Why is she picking on mom?
I know, really. One of the other things too is that once the poisoning allegation came, I think Brian Claypool essentially checked out. Although he did do a reasonably passable closing argument, it was not as strong as his closing argument in the 2016 retrial. And he never appeared in the courtroom in Florida again. Even though some days when he said he couldn't appear in Florida because he had medical appointments or things like that, he would appear on TV, on Court TV or HLN, and look just fine and dandy.
Yeah, that's how they always are.
So then the court entered an order. Pre-sentence report was ordered due in 30 days, which I think would have been July 16, 2017. Dippolito was remanded to be held with no bond, and sentencing was set for July 21st, 2017. The judgment of guilty was entered on June 22nd, 2017, and Dippolito was judged guilty of solicitation to commit first-degree murder with a firearm. A motion to permit jury interviews and motion for new trial was also filed on the 22nd, seeking interviews with alternate jurors and the juror they accused of sleeping during the trial. They also filed a waiver of pre-sentence investigation on July 5th, 2017. And I believe that's because there is a gap in her employment history, and there are some social history problems. Because there's an allegation that she moved to California with a guy and they were going to get married, and that she stole money from him and left him, and he wasn't happy about that. And then there's the whole relationship with Mike Stanley and cheating on Mike Dippolito with Mike Stanley and Mohammed Shahade. And so, yeah, they don't want a pre-sentence investigation. And there's some, websites out there that if you Googled at that time Dalia Dippolito's name, you'd probably get an escort website. And you probably, if you go through the wheat for the chaff, you probably could still find an escort website. But mostly you would find just articles about her having been an escort. And then
was she a good escort? I guess pretty good.
She was pretty good. She was able to find rich men that she could steal from.
Yeah, there you go.
And she was able to convince them that she was the one for them, and that she loved them, to the ends of the earth and back.
Right.
And they were meant to be together, and they just wanted a life and babies, and that's all she wanted with them. And she had her own money because she probably had stolen it from somebody else, or her family has money, or a combination of the two. So, order granting additional costs was entered on the July 6th for a transcript of bench conferences and motions on June 16th, 2017, regarding the motion to strike juror and impanel an alternate. A motion for rehearing was filed on July 10th, 2017, on the gag order in the 4th District. There was a hearing on the motion to permit juror interviews held on July 14th, 2017. And yet again, Judge Kelly, and this is why I love him, I would love to interview him. He demonstrated such patience when he denied this motion and explained in detail on the record why he was denying the motion. First of all, it's involving things that happen in court that could be observed by the court. There's no need to interview jurors because it's not about extrajudicial contacts. It's not like somebody walked up to them in the hallway outside the jury room and said, if you don't convict Dippolito, I'm going to kill you. Or if you do, I'm going to kill you. It is things that happen in the courtroom. And then he went through his observations of this particular juror and why he believed that this did not prove that she was sleeping. And you also see childish behavior from Rosenfeld. And, he's like, all due respect, Judge. It's like, that's not very respectful. You say, with all due respect, Your Honor. I hate younger attorneys who call the judge, Judge. If you said Judge Kelly, that's different. But referring to the judge as Judge is disrespectful. I was raised that you don't do that. And back in my younger days, if you did it to a judge, they would take you to task on the record in the courtroom. Because I saw one do it once to a very young attorney.
I think you cut out a little bit.
Judges would take you to task if you did it in the courtroom. And it's going back and forth. Okay. And we're back. Judges would chew you out if you did it. So anyway, you call them Your Honor. If you're going to call them Judge, append their last name to that to address them as Judge. And I complimented one of our younger attorneys, and my favorite attorney does it too. They say Your Honor. If they're going to say Judge, they say Judge Smith. So anyway, so Judge Kelly, if you can find the videos on YouTube, find this hearing, watch this hearing. It's incredible. Again, you'll fall in love with Judge Kelly just as I did. So The judge entered an order on July 14th denying the motion to permit juror interviews and for new trial, and this is what the judge had to say. First, the defendant's motion does not support the extraordinary remedy of conducting juror interviews. Juror interviews are generally appropriate where some misconduct has occurred outside of the presence of the court. For example, premature deliberations by jurors or conducting outside research would be matters done without the court's knowledge, which might require a juror interview. The allegations here deal with a matter which occurred in open court, whether the juror was paying attention to the evidence presented during the trial would be subject to observation by the court and does not require or necessitate interviews with jurors. Indeed, the court made all necessary observations of the jurors during the course of the trial and stated its findings on the record. Therefore, no juror interviews are warranted. Second, the defendant is not entitled to a new trial as the court, based on personal observation, found that the juror was not sleeping through the testimony presented and was paying attention during the course of the trial. While at trial in support of the present motion, the defendant has filed affidavits from persons associated with the defense team alleging that Ms. Juror was sleeping. The court, based on personal observation and knowledge, found otherwise on the record during the trial. And this is one of the things that Rosenfeld wanted to argue, that his 7 trump the court. And that's why he needs to get more evidence from jurors. He also claimed to have anonymous statement from someone that proves the juror was sleeping and another alternate was waking her up. And I'm not going to say her name. I have her name, but I'm not going to say her name. The sentencing hearing was held the 21st of July. Mike testified. Dippolito chose not to allocute. Rosenfeld read letters from Dippolito's mother and sister, which may have been from the 2011 sentencing. And this is another interesting thing. There wasn't, to my knowledge, I could be mistaken, there wasn't a single 2017 letter from anybody for Dalia Dippolito. All of the letters admitted during the sentencing hearing, attesting to what a good person Dalia Dippolito is, were from 2011. And none of them know about the things that she did to Mike while she was married to him. Rosenfeld read some additional letters from 2011. He claimed that he cried, that his presentation was stained with his own tears. He had just got married. I suspect that marriage is not going to last. He admitted Walker's report. He admitted something about Dalia's social history. The state presented their argument. The defense presented an argument. More whining from Greg Rosenfeld was heard. I think Claypool was there by phone. The defense also offered Mike's deposition. I think they're trying to argue that he was fine with her not getting any jail time, because he apparently said that in a deposition in 2011. The state presented a rebuttal argument and the court rendered its sentence. It denied the defense's request for a downward departure, which was seen Dippolito serving about 4 years in prison because they were trying to count the 8 years on house arrest. They did sentence her to 16 years in DOC. That was 4 years less than the original sentence. Without really giving her credit, the court did find that 4 of those years on house arrest deserved some recognition. And he gave her 163 days of incarceration prior to imposition of credit for 163 days prior to imposition for time spent actually in jail after her arrest, after her first trial, and after her retrial conviction. The sentencing order was issued on the 21st of July, which also assessed $518 in costs due immediately from Dippolito, which I believe she has not yet paid. It went to collections. A motion for rehearing was filed on July 24th, 2017, continuing to argue that Dippolito is entitled to develop a record on her sleeping juror claim. In spite of the court's well-reasoned explanations at the prior hearing regarding its ruling and the fact that Dippolito's allegations are not based on matters outside the record that would have entitled her to juror interviews. Dippolito's allegations are based on events that took place within the courtroom and were established on the record at her trial. Motion for bond pending appeal was filed on July 26th. The court denied Dippolito's motion for rehearing, and again, the brilliance of Judge Kelly and his patience. He entered this order on the 27th of July. The court, based upon personal observation, determined that the juror was not asleep during the presentation of evidence and was fit to continue as a juror. As the court stated before, where the court makes personal observations and reaches conclusions based on those observations, there is no requirement, parentheses, or need, close parentheses, for the court to take testimony. The court, 1, made personal observations, 2, interpreted what was observed, 3, made a finding on the record, and 4, concluded that removal of the juror was not necessary. Footnote, it is not just what was observed that is significant. Rather, it is the court's interpretation of what was personally observed that is dispositive. Dippolito filed a notice of appeal on August 4th, 2017 to the 4th District Court of Appeal, which was lodged under docket number 4D 17-2486. The state filed a motion for sanctions against Rosenfeld for failure of Dippolito to attend that June testing and examination by the state's expert. On August 10th, the hearing was held on on Dippolito's motion for bond pending appeal. The defense argued about the multiple issues to be raised on appeal, claiming they all have merit, including objective entrapment, sleeping juror, and admission of poisoning allegation during Shahadi's cross-examination during the defense case. Again, patiently and calmly, very zen-like, Judge Kelly explained why none of those issues have merit on the record. And again, this is a hearing. You can view it on YouTube. I would highly recommend it because you'll hate Greg Rosenfeld as much as I do after you watch a couple of these hearings. Because again, he was rude to the judge. He was rude to the state. I mean, there was at one point he made a comment and the state was trying to counter it. And he's like, you know, I'm talking. Well, you've been talking for 20 fucking minutes. Shut the fuck up. And I don't know at this particular hearing, I don't know if the state really had much of an opportunity because Roosevelt just kept going on and on and on and on. So the state did argue that Dippolito could very easily take her son and flee. The state also argued that she has a history of manipulating men to do her dirty work. They asserted that Dippolito planted drugs in her husband's car, tried to get his probation revoked with false claims of domestic violence and drug dealing, and ultimately attempted to have him murdered. The state established that the father of Dippolito's child, who lives in her mother's household, is a convicted felon, and played a jailhouse call between Dippolito and her baby daddy discussing an inmate in South Carolina who used a drone to escape from prison. On August 16, 2017, the 4th District Court of Appeals denied rehearing and rehearing en banc and for certification of a question of great public importance on the gag order. Order denying defendant's motion for bond pending appeal was entered by Judge Kelly. He analyzed the proposed appellate issues and explained why none of them had merit. And then he, had several findings related to Dippolito's conduct prior to the solicitation attempt against Mike and the boyfriend, baby daddy, and the fact that on the recording, the baby daddy is also heard to say, "I can't wait to be out of here and get on with our plan." And that because of the child and because of the several years in prison that she is facing, that she is not entitled or does not meet the qualifications for another appellate bond. So she will go to Florida DOC and begin serving her 16-year sentence. The mandate issued on the dismissal of the petition for review on the gag order on September 1st, 2017. An attorney filed a notice of limited appearance for Rosenfeld, Richard G. Lubin, related to the motion for sanction, which the hearing was held the 25th of September. And the order was entered the 2nd of October, 2017, finding that the remedy was to strike the witness, which was done, and the motion for costs was denied. Dippolito filed a petition for certiorari on the gag order to the U.S. Supreme Court on November 14, 2017, or that was when the docket was lodged. And on January 8, 2018, that was denied by the Supreme Court. Her direct appeal went to the 4th District Court of Appeal. She was represented by Rosenfeld and Andrew Greenlee, who represented on her prior direct appeal. The issue she raised was whether the trial court erred in allowing the state to present evidence of uncharged crimes, whether the conduct of law enforcement constituted objective entrapment, which the court erred in refusing to submit to the jury, and whether the court erred in allowing the jury to consider unsubstantiated bad acts evidence. A decision was issued on March 19th of 2019. Dippolito filed a motion for rehearing, and that was denied. But on June 5th, 2019, the 4th District issued a replacement order. And that basically expanded the findings regarding objective entrapment that weren't contained in the March 19th decision. They denied the motion for hearing and rehearing en banc, but substituted our previous opinion with the following. In a prosecution of defendant for solicitation to commit first-degree murder, the trial court did not err in allowing the state to introduce evidence that defendant had told her lover that she had previously tried to poison her husband with antifreeze. That evidence was necessary to limit the lover's testimony on direct. It also explained why the lover initially approached the police, because he did actually believe the defendant was going to kill her husband. The entrapment, the conduct of law enforcement did not constitute objective entrapment. The mere fact that the lover made repeated phone calls to defendant without police monitoring them was insufficient to show entrapment. The trial court properly admitted evidence of collateral crimes. The evidence was relevant and established the entire context out of which the charged crime arose. Conviction and sentence were affirmed, and the mandate for that issued on July 12th, 2019. Dippolito, not good enough, went to the Supreme Court of Florida, which denied her request to accept jurisdiction and denied her petition for review on September 4th, 2019. She then filed a petition for writ of certiorari to the U.S. Supreme Court on December 3rd, 2019, which I'm not going to go through. Basically, it was the challenge to the Florida State Court findings regarding objective entrapment and trying to establish objective entrapment as an issue to be decided by a jury rather than an issue to be decided by the court. That writ was denied on February 24th, 2020. On May 15th, 2020, another episode of 2020 aired titled Down Payment on Death. I haven't watched that one yet, but I will. And we'll talk about it when we talk about habeas. On September 1st, 2020, it appears that Muhammad Shahadi entered a guilty plea to aggravated stalking and written threats to kill, and he was sentenced to 364 days in jail. He may have been put on probation. It's unclear. He may have already been serving time in jail because he did violate protective orders. it's kind of murky, and I didn't go into the weeds on that. Maybe I'll look at that a little bit more closely the next time we talk about Miss Dalia. State post-conviction, Florida is weird again.
Well, you don't have to say that twice. Like, that's just a general accepted
I
statement
know.
of fact.
It's like, okay,
Florida
yeah, I'm
is just
not telling
weird.
anybody anything they don't already know.
Florida is weird.
Florida has a weird system. There is a Florida Rule of Appellate procedure for ineffective assistance on direct appeal of counsel that you raise in the District Court of Appeal. And then you can also, at the same time, raise motion for post-conviction relief in the state trial court. So that's kind of weird. So, and of course, Dalia, now being represented by Matthew R. McLean. So Rosenfeld and Claypool have both checked out. He filed in the 4th District Court of Appeal a petition for ineffective assistance of counsel, failure to argue that the trial court abused its discretion by permitting the state to use peremptory strikes on 3 African-American prospective jurors and a Hispanic prospective juror, where the record refutes the state's assertion of genuineness, failure to argue on direct appeal that the trial court abused its discretion by failing to replace the sleeping juror, or at the least conduct a permitted investigation into juror misconduct, failure to argue on direct appeal that the trial court erred by denying motion to suppress based on Florida's wiretap statute, and failure to argue the state's improper argument during rebuttal closing that defendant is as guilty as anybody has ever been in a criminal courtroom. Right there. It doesn't get any better than this. It's like Old Milwaukee. It doesn't get any better. And other improper closing arguments deprive defendant of a fair trial. A motion for Rule 3.850 post-conviction release was also filed on the same date, and that's October 27th, 2020. And ground 1 was ineffective assistance of counsel. Counsel improperly opened the door to prejudicial evidence that defendant told Shahade that the previously attempted to poison her husband. Failure to request a limiting instruction after the trial court ruled the state could present evidence of defendant's previous attempt to poison her husband. Failure to call forensic examiners, law enforcement officers that conducted search of defendant's computer and found no evidence that she searched the internet for ways to poison her husband. Ground 4, failure to object to improper remarks made by the state during rebuttal closing argument. And then ground 5, good old cumulative error. Now, this is one of the things they tried to attack the poisoning allegation by saying, well, they never found antifreeze. They never found anything on her computer. But as I recall, the laptop computer that Dalia used was found to have been destroyed. And again, she had Mike Stanley who could have looked stuff up on his computer and relayed what he found to her. So not finding it on a desktop computer that she used does not negate the fact that she could have searched. But that was their argument. And then they also said, they didn't find any evidence. They didn't charge her with poisoning. So they're trying to argue that the poisoning allegations aren't true because there's no evidence. But again, this is what Dalia told Shahade. Dalia said, I tried to poison him. I put antifreeze in his tea and it didn't work. And then they try to argue that, Shahade made inconsistent statements. Well, of course he did. He's a fucking pillhead. And of course he did, because he's going to say what you want to hear when you want to hear it. Because he's a fucking pillhead. He just wants it to end. And I think he felt a level of guilt for her being in as much trouble as she was in. I think he mistakenly believed because Mike didn't actually die, she wasn't in that much trouble. And then when there was a criminal prosecution, then, he realized, oh shit, this is serious. On January 27th, 2021, the state was ordered to file a response as to grounds 1, 3, and 4 in the petition alleging ineffective assistance of counsel, but it's not entirely clear. I think this was the 3.850 petition, not the one in the Court of Appeal. On the 6th, the state was ordered to respond to the defendant's motion for post-conviction relief, or an extension of time was granted to the state to file its response. I didn't look at the order, so I'm confused. Shahade on May 18th, 2021 appears to have been released on probation from the stalking charge. So he got out a little bit early on the 364 days in county jail. On June 1st, 2021, relief was denied on the petition for the appellate petition for direct appeal, ineffective assistance of counsel. On August 10th, 2021, the affidavit of violation of probation was entered, citing Shahade's various violations involving possession and consumption of alcohol and or drugs, in violation of his probation terms on July 31st, 2021 and August 3rd, 2021. And on that affidavit, he is listed as a violent felony offender of special concern. On October 24th, 2021, he was still free, and he was found dead in his apartment in Sebring, Florida by his brother. His cause of death was most likely a drug overdose. I don't have the official autopsy report, and there were a lot of conspiracy theories on Reddit. Surprised Dippolito has not raised something in the courts by now about it. But there were a lot of pills found in his apartment from different doctors. He had an opioid addiction. He had the issue where he was found unconscious after overdosing on drugs in March of 2017. So he had a drug problem, and it came back to bite him on the ass. Probably about 5 months after he was released from county jail. It would have been better if he'd been sentenced to a longer term in DOC, because he might have been able to get clean. The state filed its response to Dippolito's 3.850 motion in the trial court on December 21st, 2021. And in addition to filing the response, they also filed the complete record of, I think, both trials, both retrials. And they recommended denial of relief. Dippolito sought leave to file a reply, basically re-arguing each of her grounds for relief on January 5th, 2022. On August 1st, 2022, she filed a notice of supplemental authorities, providing the court with Smithy versus State, which was a 5th DCA opinion finding defense counsel to be ineffective after an evidentiary by opening the door for the state to introduce evidence that had otherwise been suppressed. That's a direct quote from the notice of supplemental authority. That's another sad case. That's a case where a woman lured her former husband or estranged husband to her house, had sex with him, and then shot him to death and claimed he raped her.
Widow.
Yeah. Yeah. And that was after years of torturing him and his kids.
Oh, and Lisa, my Black Widow comment killed your internet connection.
Oh my gosh. I'm back. Am I back?
Well, listeners, thanks for hanging out. I'm not going to sing.
Oh, yeah. No, Kyle. No, please. No.
Yeah, no one wants me to sing, believe me.
Oh my God. I've got to get some other internet. I think
you gotta get off the dial-up. What's the crazy
no,
the old dial-up sound?
it's panoramic. And the only time I have a problem with it is on Zoom.
Of course.
I
The Zoom's
really,
kind of crazy
well,
anyway.
I have a problem with it occasionally where the internet, the Google Chrome will close and then it'll reopen. So, or I've got a virus. I don't freaking know. Anyway, okay, let's wrap this up. So on August 5th, 2022, the court entered an order denying post-conviction relief. It basically adopted the state's response and its facts, legal analysis, and conclusions of law and denied relief. And Dippolito had a right to appeal, which, surprise, surprise, she did. She filed a notice of appeal on August 22nd, 2022. On March 16th, 2023, the denial of post-conviction relief was affirmed per curiam, but they didn't issue a decision or a written decision, and which they don't do a lot in Florida. Another thing that I hate about them. And the mandate for that issued on April 14th, 2023. The denial of post-conviction relief was affirmed. Dippolito has gone on to federal court. She is still being represented by Matthew McLean, who was representing her during her state challenges. She is in the Southern District of Florida. The docket number is 9:23-CV81027-DMM. That is Judge Donald M. Middlebrooks and Magistrate William Matthewman are the judges currently assigned. That could change. Although, well, they have lifetime appointments, so it may or may not change. But if their dockets become unmanageable, then it'll be transferred to another judge. She has filed her petition for writ of habeas corpus on July 13th, 2023. She is raising 10 grounds, which are the issues raised on direct appeal, the post-conviction claims raised, the IAC claims, and that is where we're going to end part 2 because
Lisa's really trying to get me to sing, aren't you?
No, I'm still talking and my internet seems to be fine. Could it be my new headphones?
We've got to get Lisa. Everybody, we need to start a Patreon to get Lisa off the dial-up.
Can you hear me now?
You're back. Yeah. I just said we're gonna do a Patreon to get you off the dial-up.
Where did it cut out? Do you remember?
I don't, because I was thinking about the vacation movie where Chevy Chase sings Moon River. So
Oh, okay.
I
So
blanked
anyway,
out my brain.
she has filed. She's got 10 grounds. We'll look at those grounds after the federal court, the 11th Circuit Court of Appeal, and more likely than not, the U.S. Supreme Court have weighed in. So, all right. Well, in light of my continued disruption, which is annoying me as much as it's annoying you folks, I may have to look at StreamYard because Zoom is not cutting it. Do you agree?
Yeah, Zoom is kind of a mess.
Yeah, I've seen that, but like I don't have it with you unless your kid uses your headphones. But to have it become unstable is annoying. So anyway, we're going to end it here. We'll talk about Dalia again when federal habeas corpus ends. More likely than not, she will not be successful and she will serve her 16 years. And even if she is successful, she will serve close to her 16 years before she's eligible for before she's released anyway. So because Florida is like you serve all your time. All right. So that is it. I think we're going to call it a day. Happy Mother's Day to everyone. I hope you
happy Mother's Day to all.
I hope you are listening and you enjoyed your Mother's Day. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLN. Kyle and I will return in 2 to 3 weeks for episode 8, State of Florida versus Danny Rolling. Rolling terrorized the college town of Gainesville, Florida for over 4 days in August 1990 when he murdered Tracy Inez Paulus, Sonia Larson, Manuel Taboada, I don't know how to pronounce his name, my apologies, Krista Hoyt, and Christina Powell. Rolling was convicted and sentenced to death in 1994 and was executed in 2006. We'll talk about the evidence linking Rolling to the Gainesville murders, his trial, appeals, and execution. We'll also look at his confession to the murders of the Grissom family in Shreveport, Louisiana. Until then, have a safe 3 weeks and good night.